Welcome back into Eye on Agriculture. I'm Brityne Rucker. A Canadian farmer is being ordered to pay more than $60,000 following confusion over a thumbs up emoji text he sent in response to a flax buying contract. We're joined now with Roger McEowen, professor of agricultural law and taxation at Washburn University. As always, Roger, pleasure talking with you today.
Good to be with you, Brityne.
Okay, so walk us through this situation and this court ruling.
Well, it is a Canadian case, but the result would be the same in the United States. So I want to start with that. But this is your typical forward grain contract situation. We had a grain elevator that contacted a group of farmers saying, hey, we're willing to buy flax at $17 per bushel, delivery in the fall. And one farmer followed up, and so the elevator called him, had several phone conversations with him, and then they sent a written contract signed in pen and ink, and they took a photo of it and texted it to him, and he replied with a thumbs up emoji. And when the time came for delivery in the fall, the price of flax had gone up 2.5 times. It was now $41 per bushel. And of course, the farmer didn't want to sell his grain for $17 a bushel when he could sell it to somebody else for 41 on the open market. So he said, no, no contract. My thumbs up emoji just meant that I got your text. It didn't mean that I accepted your offer.
Really interesting. And I understand there was a similar case in the 1950s where a producer ended up selling his farm because of a note he wrote on a restaurant check.
Yeah, that's right. That was in Virginia. Well, on the Canadian case, the court said, you sold your crop. You had past practices where you were sending text messages. And based on that, we think that, yeah, you indicated you were accepting the offer. And you're right. The same thing happened back in 1954 in the Virginia Supreme Court. One fellow had wanted to buy this other guy's farm for some time, and on Christmas Eve, he came to this farm owner's local restaurant and convenience store kind of out in the country, and they were haggling over things and kind of bluffing each other. And the farm owner, to get rid of the guy, said, "Here, I'll write out an offer to sell it to you on the back of a restaurant check." He gives it to him and said, "Well, you need to go take that to your wife to have her sign it too." So she's the cashier. She signs it. And sure enough, the court said that was a binding contract, even though they were arguing that they were just two drunks as high as a Georgia pine, and they weren't serious about it. But the point was that the buyer thought the seller was serious, and that's what matters in these situations.
Now, Roger, big question here. How does the court go about determining if these contracts are in fact valid?
Well, we have to have what's called a manifestation of intent, an objective manifestation of intent to enter into a contract on the core contract terms. So we know that we're selling a farm. We know that we're selling flax. We've got a price that's established, although we can establish price later. But if one party, if the buyer believes that the seller is serious in accepting the offer, then you've got a contract. And that's what happened in both of these situations. And I think farmers also need to be reminded, Britain, that now in the age that we live in, digital is the same as pen and ink. And that's a key point to keep in mind.
Well, Roger, as always, we learned so much from you. Thanks so much for coming on and chatting with us. Everyone stick around. Eye on Ag will be back after the break.